aggravated assault count 1. He's pleading to ag assault, the C felony. That'll be 3 years in the TDOC, suspended to state probation. He must complete an anger management class, and contact with the victim is allowed. Counts 2, 3, and 4 will be dismissed in settlement, Judge.
All right. State your full name for the record. Oh, I'm sorry. Raise your right hand. Let's place you under oath first.
I do.
Now state your full name for the record.
Clifford Gregory McCallum Jr.
Mr. McCallum, you're here today charged with a couple of different offenses, and it's been indicated you're going to be entering a plea to one charge and the other 3 are going to be dismissed. But have you seen or been shown a copy of those charges? Talked them over with Mr. Vaughn, you and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of no contest. Do you understand that means I'm not going to admit what I did? I'm not going to admit anything, and I'm not going to contest the state's evidence when they tell me what their evidence is. And as a result of that, I'm going to use their evidence to find you guilty according to this agreement. Do you understand that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand you would have the right to have a lawyer if you could not afford one? I would appoint one for you, as I've done with a public defender.
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand you would be presumed to be innocent? You would not have to testify or prove anything at your trial, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
Yes, Your Honor.
Do you understand that's going to result in a conviction that's going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
Yes, Your Honor.
Do you understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead no contest according to this agreement and waive your right to a trial?
Yes, Your Honor.
Is your decision to plead no contest today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
No, Your Honor.
Do you understand I can't accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty?
Yes, Your Honor.
Then I want you to listen to this evidence. If you'll step aside and let General Sylvie come to the
Your Honor, on August 23rd at about 2 a.m. in 2025, officers responded to Old Clarksville Pike in Cheatham County. They made contact with Dustina Wines. She had told officers there had been an argument in which the defendant had got onto top of her and placed his hands around her throat, neck, and chest area. Officers did document injuries of redness and strangulation marks around her neck. That would be the basis for the plea, Your Honor.
Well, I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be if this case went to trial.
Yes, Your Honor.
You still wish to plead no contest according to this agreement?
Yes, Your
Are
Honor.
you satisfied with your attorney's services?
Yes, Your
I
Honor.
feel like Mr. Vaughn has done a good job of representing you competently.
Yes, Your Honor.
Mr. Vaughn, do you know of any reason you should not enter this plea? Is there anything further from the state? Then Clifford McCallum in docket number 19782, upon your plea of no contest to count 1, the remaining counts are dismissed. I find you guilty of aggravated assault, sentence you to 3 years in the Tennessee Department of Corrections that will be suspended to state probation. As a condition of your probation, you must complete an anger management class as your probation officer would require. Thank you.
Just to add, I just remembered this. He has already completed that anger management
All right,
program.
and he's in compliance with what the requirements would be if he's already done it, so. All right, thank
so
you.
much.
He still needs to see the probation department. I assume you need to give that to them so that they have a record of it.
Correct. Thank you. Counts 1 through 5 are going to be dismissed, which he's actually pleading to is count 6 and 7. That's the theft of property is count 6. That's 6 years in the TDOC, suspended to supervised probation. There's no restitution in this matter. Also required would be truthful testimony against the co-defendant if required. Also pleading to count 7. That is a DUI. That'll be 11/29, suspended to supervised probation. She's got jail credit from 11/24 to today's date, so that takes up to 48 hours. The rest is just the minimums: $350 fine, loss of license for a year, and must complete a vision impact panel. She understands that the more DUIs you get, the worse the punishment is. So, you have any more?
All right, Ms. Bumpus, raise your right hand. Let's place you on the road.
I do.
State your full name for the record.
Jerry Kristen
You can
Bumpus.
put your hand down.
Jerry Kristen Bumpus.
Ms. Bumpus, you are here today on a multi-count indictment. You've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of those charges and talked them over with Mr. Vaughn, and you and he discussed the range of punishment you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter this plea of no contest to 2 of the counts and have the remaining charges dismissed. Do you understand that you have the right to plead not guilty to all charges and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand if we had the trial, you would have the right to have a lawyer and to have one appointed, as I've done with a public defender?
Yes, sir.
Do you understand that at trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you can be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you? You could bring in your own witnesses by the use of a subpoena.
Yes, sir.
Do you understand that trial you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that if you enter this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is to approve what your lawyer has worked out with the state.
Yes, sir.
Do you understand that that's going to result in convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
Yes, sir.
One of the charges you're pleading to is driving under the influence of an intoxicant. And I'm required by law to advise you of the following. Any person who is convicted of a first offense driving under the influence shall be fined not less than $350, no more than $1,500, and shall be confined in the county jail or workhouse for not less than 48 hours, no more than 11 months and 29 days. It shall be prohibited from driving in Tennessee for 1 year, provided that if at the time of the offense the alcohol concentration in such person's blood or breath is 0.20% or more, the minimum jail sentence shall be 7 days instead of 48 hours. Any person who is convicted of a second offense shall be fined not less than $600, no more than $3,500, shall be confined in the county jail or workhouse for not less than 45 days, no more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for 2 years. Any person convicted of a third offense shall be fined not less than $1,100, no more than $10,000, shall be confined in the county jail or workhouse for not less than 120 days, no more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for not less than 6 years. Any person convicted of a fourth offense shall be guilty of a Class E felony and shall be fined not less than $3,000, no more than $15,000, and shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class E felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a fifth offense shall be guilty of a Class D felony and shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class D felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a sixth or subsequent offense shall be guilty of a Class C felony, shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class C felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of any offense while accompanied by a child of under 18 years of age, the person shall be fined $1,000 in addition to the fine for the DUI offense and shall be confined for a mandatory minimum period of 30 days, which shall be served in addition to any period of incarceration received for the DUI offense. If the child suffers serious bodily injury as an approximate result of the DUI offense, the person commits a Class D felony and shall be punished for vehicular assault as provided in Tennessee Code Annotated 3913-106. If the child is killed as approximate result of the DUI violation, the person commits a Class B felony and shall be punished for a vehicular homicide result involving intoxication as provided in TCA 3913-213 subsection B2. In addition to the required sentencing, a judge may order substance abuse treatment, substance abuse assessment, conditions of probation and/or monitoring with periodic reporting using one or more of the following: transdermal or other alternative alcohol or drug monitoring device, electronic monitoring with random alcohol or drug testing, global positioning monitoring service. In determining whether a conviction is the second or subsequent offense, it does not matter whether the prior offense occurred in Tennessee or in another state. In determining whether a conviction is a second or subsequent offense, all prior convictions within the past 10 years from the current conviction shall be considered. If the person's current conviction is within 10 years of the previous conviction, the person shall be considered a multiple offender. If the person is considered a multiple offender, then all convictions within 10 years of the date of the immediately preceding conviction shall also be considered in determining the number of prior offenses. For purposes of determining if the person is a multiple offender, the state may use a conviction for an offense committed in another state that would constitute the following if committed in this state: driving under the influence, boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide. The state may also consider an offense committed in another state as a prior conviction if the elements of the offense are the same as the elements of the comparable offense in this state. For purposes of determining if a person is convicted of DUI as a multiple offender, a prior conviction for boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide shall be treated the same as a prior conviction for DUI, as long as the person was convicted of the prior offense before committing the instant violation of DUI. A defendant's automobile may be subject to seizure and forfeiture upon a second or subsequent conviction of a DUI offense. Unless a person convicted of violating TCA 55-10-401 is determined to be indigent, the minimum applicable fine shall be mandatory and shall not be subject to reduction or suspension. All fines are to be paid on the date sentence is imposed unless the court makes an affirmative finding that the defendant lacks the present ability to pay. The court shall then order a date certain before which payment shall be made should the defendant fail to comply with the orders of the court. The clerk shall notify the court of the failure for further proceedings. Payment of restitution to any person suffering physical injury or personal loss as a result of such offense, if the person is economically capable of making the restitution, shall be imposed as a condition of probation. Now, I am going to give you this sheet that shows that you have had this read to you in open court. I am making an affirmative finding that she lacks the present ability to pay due to the fact that she is indigent and has a public defender, as well as the fact that she is presently incarcerated. She'll need to sign that. Now, do you understand everything that's been explained to you thus far?
Yes, sir.
You still wish to plead no contest and waive your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges.
Yes, sir.
Do you understand? Then if you'll listen as the state tells me what their evidence would be if this case went to trial. Mr. Vaughn, Mr. Willoughby, if you'll pull that microphone up, I don't know if it's working or not. Is it working? Nope. All right, come on up.
In 19814 on November 24th of last year, officers were sitting stationary at a gas station, I believe on Jackson Phelps Road here in Cheatham County, Tennessee. They observed a pickup truck pull into the gas station, pull up to the pumps, Ms. Bumpus did get out of the driver's seat. She did go inside the store, remained inside the store for about 40 minutes. Officers then approached and ran the tag of the vehicle, which came back stolen. Ms. Bumpus, once she noticed the officers, they would state that she went back to the vehicle. The passenger in the vehicle, who's the co-defendant, gets out of the passenger seat, attempts to go to the driver's side, and then attempts to go in the store. He is taken into custody as well as Ms. Bumpus. They are separated. Once they are separated, both are very clearly under the influence of whatever substance, probably fentanyl and a methamphetamine mix, which I'll get to in a second. They talk to Ms. Bumpus. She states that the passenger does have drugs in the vehicle as well as on his person. Officers go and search him and find, I believe, 25 grams of and 17 grams of two different substances. I forget which one was crystalline and which one was suspected heroin in a sock after they took him into custody. During their interaction with Ms. Bumpus, she continually makes reference that there are drugs in the car and they do belong to the co-defendant, and she would be a witness at trial if her co-defendant goes.
All right. Ms. Bumpus, do you understand that's what the state's evidence will be at trial, that you have agreed as a part of this agreement that you're going to testify truthfully to the against any co-defendant that might be required to go to trial? Do you understand that?
Yes, sir.
And you understand that would be in compliance with what the state has said their facts are? You understand that?
Yes, sir.
Are you satisfied with your attorney services?
Yes, sir.
Feel like Mr. Vaughn's done a good job of representing you competently?
Yes, sir.
Mr. Vaughn, do you know of any reasons you should not enter this plea? Anything further from the state? Then Jerry K. Bumpus in docket number 19814, upon your plea to count 6 of no contest, I find you guilty of theft of property, sentence you to 6 years in Tennessee Department of Corrections that will be suspended to supervised probation. There is no restitution to be made. You are required as a condition of your probation to give truthful testimony against your co-defendant if you're called to do so. Count 7, you're found guilty of driving under the influence. First offense, sentenced to 11 months and 29 days in a county jail, sentenced to supervised probation on time served, which she has credit for time served from November of 2024 of 2025 until today. So she's more than completed the DUI sentence. And she has a $350 fine and cost, loss of her license for 1 year, and she must complete the victim impact panel. She'll still need to see the probation department. Counts 1 through 5 are dismissed.
All right.
All right, State versus Shannon Elliott. All right, Ms. Elliott has filed a post-conviction relief petition, and we have appointed you, Mr. Saul, to represent her.
Yes, Your Honor.
Understanding you've had a chance to speak with her about this.
Yes, Judge, we had an initial meeting downstairs earlier. She's being housed in Bledsoe County. The discovery's been released to me. I need a chance to get through that and an opportunity to then meet with Miss Elliott for the sake of doing an
Well, we
amended
need to,
petition.
give you time to file any sort of amendment
Judge.
to the petition that's been filed. And then we probably need to set it for status as to having a hearing on it. My next term here is not until July. You were here on July the 1st through the 2nd on the reader post-conviction release. You want to have the status on that day, or do you want to go ahead and set a hearing date on this one?
That'd be fine, Judge, if we do status on July 1st.
Okay. We'll set it on July the 1st for status, and if necessary, we can set it for hearing later in the month.
Yes, sir.
You said, what about to confirm the pro se motion, do it amended, and then I get time to respond to it?
Yes, Judge. Yeah.
Yes. Do you want to set a time? I think there, by rule, there may be a specific time set out in statute. Is that correct? Let's just make sure that we are complying with all of the requirements. in the statutory times for your filing your amended petition and then serving that on the state, and then the state has the right to respond.
Yeah, then we'll get a preliminary order done as well.
Okay.
I think
Yes,
the
sir.
preliminary order was already done with Mr. Vanderboort on it, so we'll need a new updated order.
Okay. We'll take care of that. We'll set it for, status on July the 1st and make sure that all of those other things are done.
Yes, sir.
All right.
Thank you, Judge.
Thank you.